will do today is that it will continue with yesterday's discussion. And yesterday we just floated the question, that is, what is the Constitution? And obviously there were several responses from all of you as well. And we were discussing that how Constitution can be understood to be a limitation on power, right? And when I say limitation on power, power found anywhere, not just the power of the government. Now I would like to give an example of why and how we can look at Constitution from this perspective. Obviously, for example, the entire syllabus that you are studying in Constitutional Law 1 talks about different limits that have been imposed on the different wings of the government and different units of the governance structure. Now, when we talk and when we say that Constitution is a limit on the power of the government, obviously we are referring to such provisions which are found generally in constitutions across the globe, not just Indian Constitution, but Constitution across the globe. For example, powers of the Parliament, powers of the legislature, the executive and the judiciary, or the manner rather, or the limitations on how the legislature, executive and judiciary are supposed to function. So, yes, the Constitution does act as a limitation on power of the government, but there are several aspects of the Constitution which not just limits the government but also limits non-governmental entities. So, for example, you have this Part 3 of Indian Constitution, which is the Bill of Rights. Before I move on to Bill of Rights, just let me clarify what Bill of Rights actually means. Bill of Rights does not necessarily refer to the Bill of Rights of United States or some specific country. Bill of Rights means a codified version of human rights, wherein human rights have been codified as a piece of legislation. Different countries have different forms of Bill of Rights. India has a form of Bill of Rights which is a part of the Constitution itself. It is not necessary that in every country Bill of Rights becomes automatically a part of the Constitution. There will be some countries, for example, United Kingdom, specifically because UK has unwritten constitution, that Bill of Rights is not a part of UK Constitution, rather it is in the form of Human Rights Act. Also, you won't find mention of human rights provisions in Australian Constitution. So there are several constitutions which do not per se have any specific Bill of Rights, but Bill of Rights can exist as a part of the constitutions or outside the constitution. So that is what I mean to say by Bill of Rights. Now what I'm saying is that when I say that constitution is a limitation on power, for example, and let's say example of Indian Constitution, Part 3 of the Constitution limits power. Though it primarily limits the power of the state. This is something that we will discuss in your next semester, that Part 3 of the Constitution is primarily a limitation on the power on the state. But apart from that also, Part 3 of the Constitution also limits non-state entities. For example, Article 17 of the Constitution, which abolishes untouchability and declares untouchability to be an offense. So it is not just limiting untouchability or prohibiting practice of untouchability by the state, but even practice of untouchability by individuals is prohibited and declared to be an offense under Article 17 of the Constitution. Similarly, Article 23 of the Constitution, wherein forced labor and vigar has been declared to be an offense. So that's why when we look at Constitution, we need to understand Constitution as a limitation on power. And it is not just a limitation on power of the government; it's a limitation on power wherever found. It even acts as a limitation on power of individuals. The second reason, so this is one reference to the constitutional text, which will help us understand why Constitution acts as a limitation on power per se. The second would be that almost all the laws which are made, which even try to regulate private conduct, derive their legitimacy from the Constitution. This is something that all of you have already mentioned yesterday when you were talking, and you were discussing that how in this entire hierarchy of norms, Constitution is a higher norm as compared to other pieces of legislation. Now, because Constitution provides legitimacy to other inferior norms or other, and when I say inferior norms, I I would like to mention, for example, legislations passed by the parliament or by the state legislative assemblies, rules, ordinances passed by the executive, etc., etc. So all other forms of rules, regulation, whatever can be called law, derives its legitimacy from the constitution, and that is the reason that one of the challenge, the one manner in which we can challenge any law of the land is whether that law of the land is in fact constitutional or not, whether the law of the land is in conformity with the constitution. So that means that even if directly constitution is not regulating private conduct, indirectly it does regulate private conduct because it does provide legitimacy or a guide, sort of a framework within which all other legal rules have to operate in a given territory. So this is how we understand constitution as a limitation on power. Now, the second aspect of constitution, which I think should be discussed before we proceed to discuss constitutional text in detail, is how do you understand constitution? Do you understand constitution as an aspirational document, or do you understand constitution as something that must resonate with the practices of the everyday practices of the society in general? Now, this distinction is very much in the past few days has become a very prevalent discourse in constitutional debates, and you must have heard about those discourse called the conflict or the interaction between constitutional morality and social morality. Now, I would not like to go into detail of how law and morality themselves are related, because that is not something that we can discuss within the scope of the syllabus, but you have been opened to this debate when in your jurisprudence 1 lecture when you were discussing heart, and I'm sure a heart-cooler debate must be mentioned in your classrooms, wherein this law morality conflict and discourse was laid open. Financial Explorer case in jurisprudence 1 also tries to bring some points of the law morality debate into question. Now, without going into the debate of whether morality is a part of law or not, let's just stick to our basic understanding of how we look at constitution and how the recent debates should force us to think the manner, force us to contemplate how constitution should be perceived as. Now, this is a question to which I have no fixed answer, and I would like to believe that there are no fixed answers in law, because law is as subjective as any other discipline of humanity. But what I would like to throw open before you, and this is something that we will keep on discussing as and when we move along with our discussion of constitutional text, that there is one way of looking at constitution which says that constitution is aspirational. And when I say aspirational, it sort of enunciates or elaborates on the ideal form of society or ideal form of governance structure that we want a society to be arranged in. So an ideal form of social arrangement is something that is provided by the constitution. That is one way of looking at constitution, and that way is when we consider constitutional to be aspirational. Now, this aspect of constitution was something that even Dr. Ambedkar in Constituent Assembly debate focused on, and he was talking in context of constitutional morality, and what he said is that constitutional morality has to seep in. It has to be inculcated. That means that constitution and social arrangements are not a mirror image of the constitution, and constitution is not a mirror image of the social arrangements that we live in. Rather, constitutional values, aspirations, and ideals are something that have to be reflected or inculcated in our social arrangements. And that is what even Dr. Ambedkar considered when he was talking about constitutional morality. So that is one way of looking at constitution, wherein we look at constitution as aspirational. Okay. Now, once we consider constitution to be aspirational, there is another very interesting debate in constitutional discourse that we often come across, and that debate is the debate between how do we understand constitution, whether we consider constitution to be in an original form, or do we consider a constitution to be a living constitution, right? Now, when I say that, so once you, if you subscribe to the view that constitutional is aspirational, then you will have to also qualify what is the aspiration that constitution talks about. If the fact that constitutional, or is the view that constitutional is aspirational, only confines itself to what has been said in the text of the constitution and what has been laid down, and do you have to rigorously follow what has been laid down in the text of the constitution? Or when you say constitutional is aspirational, you talk about constitutional as having some minimum content of morality in it, okay? And I'm saying minimum content of morality so that we don't enter into the discourse, law morality discourse. That if we feel that there is some minimum content of morality which is a part of the constitution itself, then do we agree on the fact that as morality changes, or as the demands of society changes, the constitutional aspirations should also keep on changing? That the aspirations of constitutions also keep on changing. Aspiration, even if constitution is aspirational, the aspiration is not a fixed concept, or those aspirations cannot be codified or solidified in some fixed form. Rather, those aspirations are as fluid as social change, and it would require, and they can evolve over a period of time, right? So that is one question that I throw open to you, and we are not trying to find an answer to this question. It's just a question that you have to ponder upon. And whenever you look at any constitutional debate or discourse that we are having, my only suggestion to you would be that look at it from the perspective of these two questions. That is this constitutional issue an issue about limiting the power first, and is this constitutional issue an issue about considering the text of the or interpreting the text of the constitutional in order to reflect the aspirational aspect of the constitution, or is this issue about interpreting the text of the constitution in a manner that conforms to the letter of the constitution itself without taking into consideration the aspirational aspect of the constitution?
Ma'am, can you please slow down a little?
Okay, yes, I'll do that.
Just repeat the last thing that you told us about the aspirational part.
Okay, fine. So, what I was saying was that there are two questions that you need to think. Every constitutional issue, and this is just my suggestion, and every constitutional issue must be interpreted by asking yourself two questions. First, whether this constitutional issue, any constitutional issue that we come across in the course of our discussion, whether this issue is an issue about limitation on power. And if it is about limitation on power, where is the way that the power can be found, and what is the limitation that is provided for on that power, right? And the second is whether we are understanding or considering constitution as something we are interpreting constitution as an aspirational document, something that does not necessarily reflect the social arrangements that we are living in, but it is an ideal and an aspiration, and the social arrangements have to be reformed in a manner or evolved or changed in a manner that meets the aspirations which have been elaborated in the constitution.
Excuse me, ma'am.
Yes.
Ma'am, can you please give some illustration on these 2 points?
Yeah, definitely, I'll do that. Let me just answer Dinesh's question, then I'll come to yours. Now, if we understand constitution as an aspiration, then we will also come to the conclusion that the social arrangements are not always in sync with the constitutional arrangement. Now, because you asked, let me give you an example. Now, there are For example, most of the social arrangements are patriarchal, rather all social arrangements are patriarchal in nature, right? Now, constitution or also all social arrangements have caste as a dominant factor in how we interact with each other. But the constitution, when you look at the constitution is talking about right to equality, wherein irrespective of gender, caste, religion, etc., all individuals are treated on the same pedestal. So considerations of gender, considerations of caste, consideration of religion, etc., do not matter in your treatment of individuals. That is what the constitution aspires, right? But the constitution, what is the aspiration of the constitution is not reflected in our social arrangement. So that's why in your social arrangement you will find that gender, caste, religion, race, all of these form important considerations and do play a role in how individuals interact with each other. That means that there is definitely a gap between the social arrangements and what the constitution demands of the society. Now, when we look at this gap, what we may ask ourselves that when we are interpreting any issue, constitutional issue, are we going to interpret that issue according to what the social arrangements demand of us? Or are we going to interpret that issue in conformity with what the constitution aspires to be? Now, let's take the example of Sabrimala. Now, I am taking the example of Sabrimala because this is a recent debate, something which is going to be taken up by the courts again in the review petition, and something which very clearly brought forth the point of this conflict between constitutional morality and social morality, right? Now, the social arrangements demand that women should be denied entry into the temple because of whatever reasons enunciated by the believers of Lord Ayappa. Now, however, if you look at the majority judgment, what majority judgment is saying that irrespective of what the social arrangements demand, constitution must be interpreted in a manner wherein the individuality, self-dignity and right to equality is upheld at all cost. And in that case, distinguishing between men and women on the basis of sex and on the basis of menstrual, or on the basis of women undergoing a biological process called menstruation, and based on that, denying entry to women to temple is something that constitution does not allow for. Now, what was done by the majority judgment in this case was that constitution was considered to be something, or constitutional values were considered to be something which are not reflected in the social mores or social morality. But nevertheless, constitutional values were given precedence over the social morality, saying that irrespective of how social arrangements are structured, what we are going to do is that we are going to interpret these social arrangements vis-a-vis the constitution. Now, I am not going into several other nuanced debates in Sabrimala, but just because we wanted an example that how constitution is considered to be an aspirational document, and it is expected that the social arrangements would evolve in a manner to meet the constitutional aspiration. It is not necessary, and this is something that all of you asked, it is, and I think someone in this section or the other section was asking yesterday itself, it is not necessary that those aspirations are always translated into reality, right? So, despite the fact that untouchability is abolished under Article 17, you will still find practice of untouchability in several parts of India. So that means that what constitution says or what constitution aspires to be is not necessarily what we find in our social arrangement. So there is a gap between what the constitution aspires to be, what the constitution or the aspiration that constitution is about, and what the social arrangements are. And whenever we are interpreting the constitution, you always have to consider this point that are we going to interpret the constitutional provisions on any issue that becomes a constitutional issue in a court of law?
Excuse me, ma'am.
Yes, sir.
Ma'am, in Sabrimala case, why should we are not respecting the religion? Because
So that's why I said I'm not going into the details because that would require another lecture itself. So I'm just giving you an example of how the majority decision was interpreted, right? Now, your question is obviously very relevant because there are conflicting values that we talk about, and the question is which value you are going to give preference to. Now, there are two values that we are talking about in Sabrimala, two conflicting values, whether community rights must trump over individual rights or individual rights must trump over community rights. Right to religion is a community right. Right to religion is something that is enjoyed by a community as a whole, though it is also enjoyed by an individual, but it is also enjoyed by community as a whole. And the second question is whether right to individual must always act as trump over all other rights. Now, when we look at constitution as a limitation on power, you have to understand that there are different hierarchies in the society in the manner in which how power operates. So at the topmost of this hierarchy, what you will find is the state, right? So state is the most powerful of all forms of institution in the given nation-state model that we live in. Below that, you may find society, and society may consider of different social arrangements. The social arrangements may be based on class, it may be based on caste, it may be based on religion, right? And in the third grade, what you find are individuals. So what you see is that individuals subject themselves to the power of the society, based either on class, caste, religion, gender, etc., etc. And all these groups of individuals who have come together, arranged themselves together on the basis of class, caste, religion, sex, etc., etc., are subjected to the power of the state itself. Now, once you understand constitution as a limitation on power, you have to understand that the weakest link in this hierarchy of social arrangements or groups in social arrangements is an individual. Now, the manner in which we are understanding, and if we are interpreting the constitution as a limitation on power, right? If we are interpreting constitution as a limitation on power, and all of you are free to disagree with it, you will have to give priority to the individual over all other forms of domination. So individual rights will trump over any kind of group rights or any kind of considerations based on caste, class, religion, sex, gender, etc., sexual orientation. They have to trump over such rights. However, if you are just confining the definition of constitution to a limitation on the power of the state, then you may argue that constitution and social arrangements need not necessarily act in sync with each other. So, Bharat, I don't know if I answered your question, but I'm just trying to explain how this entire structure of the constitution, if you are at all understanding constitution as a limitation on power, you will have to understand the structure that we are talking of, wherein state comes at the top of hierarchy in power, therein followed by social groups arranged on the basis of any of the several considerations like caste, class, gender, sex, etc. And at the lowest rung would be an individual. So now the question that you have, and that's why I said this is the question that you have to ask yourself, and this is not something to which you can have a conclusive answer. And the question you have to ask yourself is that if at all constitution is acting as a limitation on power, then who all are we going to limit? Are we just going to limit the state, or are we also going to interpret constitution in a manner which limits the power of social groups, different social groups that assert power over individuals in the name of religion, caste, class, gender, sex, sexual orientation, region, etc. Now, that is the question that you have to ask yourself. And by asking yourself that question,
ma'am.
Yes.
Ma'am, usually Muslim women are not allowed in mosque. So can she file a case against it also or not?
Okay, Basan. They can. not. They can. There were several petitions filed at least for entry of Muslim women in the dargahs. So those petitions can definitely be filed. That there is no bar on filing of petition, right? So it is not a question of one religion having prominence over other religion or another religion having prominence over one religion. So please try to understand it at a conceptual level first and then bring in examples. Now, when we are talking about constitution as a limitation on power as a concept, what you have to understand is, just because I gave the example of Sabrimala, it does not mean that other religions are not equally patriarchal. All the religions, all social arrangements in the world is patriarchal. That is the core feminist take on, and the feminist methodology of critique is the same, that it starts with patriarchy, that human social arrangements are patriarchal in nature, irrespective of wherever found and in whatever manner they are arranged. However, having said so, what you have to understand is that when we are discussing about constitution in a conceptual manner, we are not passing decisions on specific issues. What we are trying to do is, with the aid of examples, we are trying to understand whether we should understand constitution in this perspective. That is, whether constitution can be understood as a limitation on power. Now, if constitution is understood as a limitation on power, wherever found, then it has to equally limit the power of social group as it limits the power of state. You cannot then argue that religious social groups are free from constitutional rigors, but the state is subjected to that constitutional rigor, right? But if you don't agree with this interpretation of the constitution, which you are free to do so, and you may come to a different conclusion based on your understanding of how constitution should operate, and if you only take the confined meaning of limitation and say that constitution is a limitation on the power of the government, then you need not be bothered with these social groups arranged on the basis of different considerations. So that is how you have to understand constitution. And this is an answer that you have to find for yourself. I can only suggest you the methodology that you may use for observing or critiquing or analyzing any constitutional issue. But this is an answer that you have to come to by yourself, that whether you understand constitution as a limitation on power wherever found. Okay, first. And second, whether constitution is an aspirational document or constitutional is a document which must reflect the social arrangements at all times. Now, this is a very old debate in law itself, that whether law must reflect the social arrangements or not. Now, if we say that law does not reflect, and when I say law, even constitution does not reflect social arrangements at all, I would be wrong in doing that, because many a times our understanding of every issue is determined by the conditions that we have grown up in, and the interpretations of law generally reflect those subjectivities. So social arrangements do find a way in how, or social understanding or social morality does find a way in how constitution is interpreted. But having said so, do we also understand constitution as an aspirational document where we are not bound to always interpret constitutional provisions in such a manner that always tries to conform constitution to social arrangements? Rather, should we interpret constitution in a manner where social arrangements are expected to evolve into constitutional aspirations or conform with the constitutional aspirations, right? This is where I would stop with regard to this part of discussion. There are few questions. Does constitutional value and social morality be interpreted harmoniously? It may be, Ravikant. That's why I'm saying that depends on the kind of issue that you are dealing with. But first you will have to define, at least in some structured manner, what do you understand by constitutional morality? What is it that constitution or that your constitution is about? what is it that Indian Constitution is about. Only once we define that would we be able to understand whether there is a conflict between social morality and constitutional morality or not. But if you understand Constitution as an aspirational document, and in those situations where there is a definite conflict between social morality and constitutional morality, you will have to interpret, give privacy to constitutional morality over social morality. If you interpret Constitution as a document that talks about aspirational values, in those situations you will have to give primacy to constitutional morality over social morality. Otherwise, in other situations, it may be harmoniously interpreted. Okay. So I would like to open the house for discussion now. In case anyone has any kind of question, didn't understand, because it may become a little difficult because we were into too much theoretical discussion. So in case you didn't understand it, just let me know, and then we will move on to, and if there are no questions at all, then we will move on to our citizens. First thing. In case you need a repetition of what has already been said, you can again ask.
Ma'am, could you please repeat just hold on. The social arrangement thing that you mentioned?
Okay, fine. So what I was saying was, simply put, I will try to simplify it further, that we are, the second-ish question that I floated before you was that is Constitution an aspirational document? Okay. Now, if indeed Constitution is an aspirational document, then it means that there must be some kind of disparity or gap between what the Constitution demands of us and how we arrange ourselves socially. Now, the example therefore that I gave you was, for example, Article 17, prohibition of untouchability. Article 14, that says that there should be no discrimination on the basis of caste. So caste has been removed from at least constitutional consideration. Caste cannot be a factor on the basis of which constitutional decisions are taken. But in our everyday life, caste is a very relevant factor on the basis of which we make our everyday decisions. You get married on the basis of caste. If you look at matrimonial advertisement, all of them are segregated on the basis of caste. Gender is a very important issue on which we distinguish ourselves. So, for example, most of the application forms do not even have a slot for non-heterosexual genders. They would not even recognize someone who is not a male or a female, or someone who is a female or recognizes with a male. So, gender fluidity is not a part of a social arrangement. Now, having said so, now the question that comes before us is that obviously what we can perceive is that there is a disconnect between what the Constitution demands and how the social arrangements are. Now, the second question therefore that we have to ask is that whenever we face any constitutional issue, are you going to interpret constitutional issue by giving primacy to the constitutional aspirations? Or are you going to interpret constitutional issues so that constitutional aspirations are brought to the level of social arrangements, right? Now, if you are understanding Constitution as an aspiration, you have to interpret every constitutional issue that comes before you in a manner that the social arrangement or the issue that you are taking into consideration is brought to or is interpreted in a manner or is legitimized or delegitimized in a manner that brings it closest to the constitutional aspiration, right? And that is why this question is a question that you have to ask yourself as to whether Constitution is an aspirational document. I hope that was clear, and if not, I will repeat it again.
Clear, ma'am. Thank you.
Okay, fine. Any other question? Okay, if there are no other questions, let us come to the second concept, and this is something that all of you must be aware of. That is the concept of constitutionalism. Okay. Till now we were talking about constitution. Now let's talk about constitutionalism. And is there a difference between constitution and constitutionalism? Now, the manner in which we constitutionalism, and this is something that one of you said in the last class, I think. I don't know if it was the section or not. That it is a core set of principles which every constitution does have. Okay. Now, the principles of constitution, or the principles on the basis of which constitution is governed, can be very simply put, and I'm not going into the intricacies of constitutionalism, but very simply put, it is the principles on the basis of which a constitution is governed that will be considered constitutionalism. Now, this may also answer Basant's question vis-a-vis Sabrimala issue. So, constitutionalism would therefore require you to deliberate upon what is the content of constitutionalism, right? Whether individual liberty is the content of constitutionalism or not. If individual liberty is the content of constitutionalism, the text of the constitution has to be interpreted in sync with the idea of individual liberty. However, if individual liberty is not something that you consider to be a part of constitutionalism, you will not interpret the text of the constitution in accordance with individual liberty. So, constitutionalism is the principles that form the core or essence of the constitution itself. Now, what are those principles that are a part of constitutionalism is again a matter of debate. Okay, again, no conclusive answer. But obviously, there are certain universal principles which we find across the globe, which there is a sort of universality to some principles which have been considered to be a part of this idea of constitutionalism. Now, the second important aspect of constitutionalism is that the idea of constitutionalism does not require a text necessarily. So you don't need to have a text of constitution or a constitution written or unwritten, both forms of constitution, in order to have constitutionalism. And please keep that very clear in mind. It is quite possible for a country or a state to have constitution, but no constitutionalism. Because the constitution is being interpreted in a manner which goes against the idea of constitutionalism, or does not conform to the principles of constitutionalism. So it is quite possible for a state to have constitution but not constitutionalism. And converse is also true. It is quite possible for a state to have constitutionalism but no constitution. So basically, when we are talking about constitutionalism, we are talking about some set of beliefs and principles that we consider are essential for the functioning of a society. And we would and the state is being organized in a manner that those principles are given primacy in almost all forms of social arrangements, right? So this is the difference between constitution and constitutionalism. So what constitutionalism talks about is the principles that are essential for or which form the core or essence of constitution. Constitution is generally the written rule or the unwritten rules or the text maybe, which would let you know how your political structure is going to be structured in, or how you are going to structure your socio-political structure. So that is the difference between constitution and constitutionalism. So in case you have any question, just let me know. If not, then I will proceed ahead.
Ma'am?
Yes.
Ma'am, from where we can derive these principle? Mean if there is no written constitution.
Yes.
So from where we can derive these principle of constitutionalism?
Yes, you can. For example, UK does not have a written constitution, right? But there are already principles, and most of the law of UK is a judge-made law. So the principles, but there will be a sort of consensus on what are those principles that we consider to be important enough such that those principles will be applied whenever required. Whenever you are interpreting any constitutional issue, you are going to fall back on those principles. And that is how you can have constitutionalism without even having a written text of the constitution. UK being one of the examples. And and it is not even necessary to have one. For example, let's for the sake of debate just argue that let's say we consider equality to be an essential aspect of constitutionalism. Okay, let's assume that. Now, a country which does not have this concept of constitution, okay, but is still governed, by principles of equality, would be considered to have would be considered to have constitutionalism, even though it does not have a constitution. So that's why it is not. You have to understand that constitution. You have to understand, and because we are trained in a manner where we consider law to be confined to the text passed by the legislative wing of the government, that's why we find it very difficult to understand that law operates even beyond the text. That text is not something that qualifies the law. Text only makes the reading of law easier, but law is present even and the operation and the influence of law and the manner in which law is influenced happens most of the time outside the texts that are brought before, or the text that we read, or the black letter law, or the codified pieces of legislation. So that's the example that I gave you. Let's assume equality or liberty are something that you consider to be essential to constitutionalism, and there is a country which does operate on the basis of these principles of equality and liberty, wherein equality and liberty are upheld at every step of the way. In those situations, constitutionalism is there even though there is no constitution. Yes,
excuse me. But ma'am, who will decide this is the principle of constitutionalism or this is not? Because if there is no written constitution, so how will we will decide that this is the principle of constitutionalism and this is not?
Yes, again that's why, Basant, you will have to stop looking for conclusive answers. Law does not give you conclusive answer. There are different arrangements who decide what is and what is not a principle of constitutionalism. For example, the primacy to determine the principles of constitutionalism in India resides with the judiciary. So judiciary determines what is and what is not constitutionalism for now. So there will in every social structures, in every state, there will be different agencies or different institutions which will determine what is and what is not constitutionalism. But you will not be able to have a singular answer as to what is exactly these. This is the checkbox that these values need to be present in a specific legal arrangement in order for it to have constitutionalism. And if it does not have these values or these concepts, then it cannot consider to have constitutionalism. You do not have a checkbox. But by experience, if you try to draw a comparative analysis between this idea of constitution and constitutionalism, what you will definitely find is that many of the basic principles like separation of power, independence of judiciary, the concept of equality, liberty, all these do resonate in the idea of constitutionalism followed across the globe. So you will never have a conclusive answer. So if you are looking for a conclusive answer, it would be difficult to come to a conclusive answer. But you can still find some universal values that can be definitely considered to be a part of constitutionalism. It will not be exhaustive, obviously, because every state, every society will have a different take on what is it that is constitutionalism. But you can definitely find a sort of overlap between at least certain values wherein there is some kind of universality as to what constitutionalism is. That's why concepts like separation of power, concepts like concept of liberty, equality, etc. do resonate with the idea of constitutionalism. And that is how we understand constitutionalism, at least in the present time. Yes, Ravikant, rule of law also. Maybe rule of law as well. Again, no conclusive answer, but yes, maybe rule of law as well. At least going by a comparative analysis of how constitutionalism is understood, rule of law may be considered definitely to be a part of constitutionalism. I hope, Basant, that your question was answered. If not, maybe you can again sort of repeat your question and I will try to answer it.
No, ma'am, clear.
Okay. So there is a question in the chat box that can basic structure qualify as a feature of constitutionalism? maybe under the Indian Constitution we can say that because when we say that there is something immutable about the Constitution itself, then you can argue for basic structures to be a part of constitutionalism. You can. But when we go into the basic structure debate, maybe we can come back to this, whether basic structure can qualify as a part of constitutionalism or not. But yes, you may argue for that. But you need to understand basic structure is a doctrine which is being judicially created, right? So at some point of time, at any point of time, judiciary can, let's say, have a larger bench and review Keshwar and Bharti and completely do away with this basic structure doctrine. Now, would that be allowed? If you go by the principle of constitutionalism and do consider basic structure to be a part of constitutionalism, then that would not be allowed. What you would rather argue, but a better way to argue would be many of the principles which are considered to be a part of basic structure are also a part of constitutionalism per se. Okay? So that is a better way to argue it, that basic structure doctrine itself is not a part of constitutionalism, but there is definitely an overlap between what is considered to be the basic structure of constitution and what is constitutionalism. So what I will do is, because there is one question at the beginning, can I provide class notes? No, part. I will not provide you class notes, but I will definitely provide you reading. Because you are graduate students, so I don't think that is the manner in which we are operating. But I will definitely provide you all the possible readings which you can go through, and you can come with those readings, and in case of any doubt, or if you want to clarify or even discuss or comment on those readings, we can have a discussion in our classroom. So what I will do today is that I will be uploading on the Google Classroom an article by Jeremy Waldron, okay? And this article is basically, the title of the article is Constitutionalism, a Skeptical View. Now, it's a long article, and I understand that, and it's a 46-page article, and I understand that you may not be able to read the entire article, but at least for tomorrow, but at least I would request you to read the entire article over the weekend and read at least some portion of it for tomorrow's class, so that we will further have a discussion on constitutionalism tomorrow, and from day after tomorrow we will start with federalism. Okay. I hope that sounds fine. And in case you have any questions, you may ask. Okay. Just let me know in case you are having a problem in understanding what I am saying, or you want me to slow down, or you want me to repeat. Just let me know, because even I am trying to understand how this digital platform is going to work. So I am as less experienced as all of you are in using these platforms. We have only used it for a few months in the last semester. So just let me know if you are having any problem in comprehending. Okay, Sagar, just email me your institutional ID. Email it to me. Just don't type it on chat box, and I will add you to the classroom too. What you can do is, I will be uploading in 5-10 minutes the Jeremy Waldron article, and please go through that article, and then we will have a further discussion on that article itself as to how that author is trying to understand the Constitution. Okay. Thank you, everyone.